our luncheon session is on institutional design. I wanted to start by welcoming you all to Washington. You're here for something that's both very atypical and very typical. The atypical is the snow. We get this amount of snow only about every 10 years or so. The typical is the complete dysfunction in removing the snow, which was almost 2 weeks ago. But maybe that's a metaphor for something. I won't speculate further. So our panel is about, as I said, institutional design. You can think of institutional design as the engineering part of implementation of competition law, as opposed to the substantive, what should the law actually say, which in papers that Bill Kovacic and I have worked on, we basically said that's the physics, which is cool and exciting and theoretical, as opposed to the engineering, which is somewhat more grubby, eminently practical. But of course, you need both of them working together for anything to go in the right direction. And so we've got a panel that's going to work through the European experience with the DMA, starting with what we've learned so far from the implementation of the DMA. We're sort of, 4 years in, 2 years after the designation of gatekeeper entities and the full application. And so we thought we would start with the distinguished panel with what do you think about how it's going? And do you have praise or criticism for the way in which the institutional design and implementation has worked out? And the focus here is, just to be clear, not to relitigate particular cases, but to use the cases as exemplars of how it's gone, how it could be done better, traps we've avoided, et cetera, et cetera. So I thought we have Alex with us by Zoom, who unfortunately was unable to travel, but desperately wanted to be included. And so through the marvels of technology is here with us. So Alex, let me start with you and just sort of ask you to talk for a couple of minutes about your perspective on how things have gone so far.
Yes, thank you very much. Did you hear me well?
Excellent.
I'm really sorry not to be with you. It's not the effect of the visa ban. I'm not that important, but of start of a pneumonia, and so it was difficult for me to travel. But indeed, I really wanted to participate to this debate and to this conference because I really like it. So basically, if we can take stock about the first 2 years, and in particular regarding the institutional framework and the processes. First, I would say that, yes, we see some first effect of the DMA. Remember, the DMA aims really to make the internet great again to some extent, because it aims to go back to the promises of user empowerment, decentralization, all those kind of things, So beside contestability, it's really about, making the internet great again, and also with more innovation. And we can see that already. Users have more agency on their data, more choice about different app or even app store. But of course, Rome was not built in one day, and you cannot, go back to those early promises in 1 or 2 years, okay? And especially because, and it was discussed in the last panel, you have the headwinds of the Trump administration who clearly don't want to make the internet great again, okay? Because they favor big tech over small tech. And I don't think, because it was discussed in the previous panel, whether it's US versus EU, but I think it's more big versus small, and most of the beneficiary of the DMA have been so far, and would be more if the DMA is more effective, US small tech, okay, not European small tech, unfortunately, to some extent, but that's the reality. So it's a learning process where every stakeholder have to learn a new role. The Commission has to become a regulatory authority, which it has never been in the past. It was an antitrust authority, a trade authority, but not a regulatory authority. So that's a very new role that the Commission has to learn. The gatekeeper have to learn to be regulated and to change their attitude from move fast and break things and break law and break everything to complying with law. When business user and end user like us have to learn to choose. And this is a very important cultural shift that cannot happen again in 1 or 2 years. Now, just to specific point on the process that comes from a study we did at CERRE, and so in terms of disclosure, so I am actively part of this think tank CERRE, which is financed by big tech, by small tech, and by regulatory authorities. So by different interests, I would say. What we show in that report that we already discussed, in fact, last year in the conference last year, is that there are several mechanisms into the law, which is, making very much the DMA close to responsive regulation. So it's not that the Commission knows everything and impose it to the gatekeeper, but it has to orchestrate an ecosystem of compliance and enforcement with different mechanisms, with informal and formal mechanisms. And regarding informal mechanisms, what we think could be improved is, when I say we, it's not me, but I mean, it's my co-author, so Giorgio Monti and Richard Fisi, mostly, and me, that the regulatory dialogue that we have mostly bilaterally now between the Commission and the gatekeeper should be a trilateral dialogue with the business user included, because that's how you do in regulation. In antitrust, indeed, it's a dialogue or an adversity between the antitrust authority and the dominant company. Here, in regulation, you have to have a process which is involving more. We also need more guidance from the Commission on compliance acceptability. So here again, in antitrust, normally you don't adopt guidelines, you learn by cases. But here, when you are in regulation, I think a bit more guidelines will be helpful. We also have a number of compliance tools in the law, in particular the compliance report of the gatekeeper, and they have to appoint a compliance officer. And clearly here, I think gatekeeper have vastly underperformed because those compliance reports, the second generation of March last year is better than the first of March 2 years ago, but still we miss a lot of indicators, a lot of quantitative indicators on, for instance, whether the opportunities which are created by the gatekeeper have been taken up by business user or by end user. So for instance, are the end user porting their data from one gatekeeper to another players, or are interoperability asked to the gatekeeper? But we have very little data on this, and we have very little data on whether, if it has not been taken up, why so? And the last thing I would say is that so we need better compliance report. And we need also a more responsible compliance officer. We were surprised that when we did our interview, very few business users knew who was the compliance officer of the different gatekeepers. So clearly they don't seem to have a big role, and they are not very visible. So maybe they need to be more important and also more responsible of the way the DMA is implemented by the gatekeeper. And lastly, we were calling for a more specification decision. This is the possibility that the Commission has to clarify the law, because in the previous panel we were discussing whether the DMA is clear and self-executing. It's true that it has sometimes been presented like that, but I think it's impossible that a law in digital is self-executing given the complexity of the digital environment. So, very often you need to, clarify the law through specification decision. And the good news is that the Commission has now done it twice with Apple and has opened a specification process for two additional decisions for Google. And that would really be helpful because that helps to organize, in the case of Apple, the interoperability, vertical interoperability, and in the case of Google, again, vertical interoperability, and the porting of data from one search engine to another. So basically, I would say,
Alex, if I can
it doesn't go that
ask
far.
you to wrap up because
Yeah, exactly. We are in a good track. It goes in the right direction, but we need more dialogue, more guidelines on what is acceptable, and better compliance report.
Great, thank you. So Jérémie, reactions? I mean, are we making the internet great again? Will there be more job prospects for compliance officers with higher pay and higher status? And is that going to get us where we want to go?
Yeah, I'm an optimist, so I'd say yes to all of your questions. But now let me give a bit more detail, and just so the audience know as well, the perspective from which I'm coming to this discussion. Almost in your That's really close now. So now I work as a lawyer in Brussels in a law firm called Geradin Partners. But before joining that law firm in September, I was working for a media company in the Nordic called Schibsted Media. So I was, in fact, I was a business user, as you call it, and I had the chance to engage with the Commission very early on from September 2023 on exactly how the gatekeepers should comply with their obligation in relation to App Store. So a lot of discussions about the Article 5.4 on steering, but also in relation to the Google self-preferencing obligation in relation to search. So I come to this debate from that perspective. In terms of disclosure, I've made some now. I've been fighting this battle against gatekeepers, so I have a certain point of view. And as a lawyer now at Geradin Partners, we represent a lot of business users in the DMA. So I'm coming from that side of the debate. I can't disclose all of our clients. That would be unethical, but at least you see where I'm coming from. So just reacting to one of the points that Alexandre made at the end, I was a business user for 2 years. I had no idea there was actually a compliance officer at the gatekeepers. And so no surprise here. And certainly we have never been contacted by the compliance officers at the gatekeepers to engage on compliance. A few observations from me on the last 2 years. I mean, there were at least two things, or two criticism, maybe three criticism leveled against antitrust that led to the adoption of the DMA. One of them was speed. Another one, I think, was scope. And then the final one was remedy. I mean, there were more criticism, but it is those three I'd like to focus on for a minute. Speed, I mean, we've seen examples such as the Google shopping case, which lasted 8 years. We saw the example of the Apple steering case, the antitrust one, which lasted 5 years. And so what's interesting now is we see the same cases or very similar cases that have been prosecuted under the DMA, so we can make comparison. So if you take the Apple cases, as I said, the steering case and antitrust was, 5 years, 250-page decision, and limited to music apps. So it was a problem of steering in music apps, extremely narrow. I think also of the ACM in the Netherlands decision against Apple, which was about the fee this time for dating apps only. I mean, I think dating apps fulfill an important function in society, but there are also other types of apps that would deserve not to pay the commission of Apple. So if we're looking at what the DMA produced in the last 2 years, we have in the area of app stores, we have the steering decision. 13 months. So the commission almost stuck to the deadline in the DMA, which is a soft deadline of 12 months. A decision of 67 pages versus 250 pages. And so now we know that the commission is working at a pace of 50 pages a year, more or less, if you compare the two cases. But also you have a a decision that applies to all app developers, right? Benefits everyone. So in terms of speed, in terms of scope, I think the DMA is clearly delivering here, you know, what the drafters had in mind. And why is that? I think, well, first of all, you know, unlike in the, if you read the Apple decision, the antitrust decision, it's quite interesting. There's, I don't know how many, maybe 100, 150 pages about market definition to define, you know, the Apple App Store as the market, and then dominance, which still took a lot of pages once you had defined the App Store as the market. That's a bit more surprising, but, and then if you look at the, the DMA decision, it's the gatekeeper designation. This was all taken care of before, right? So the DMA here has at least got rid of, you know, the market definition and the dominance aspect. We're just diving into straight conduct, and the conduct then is, you know, about whether they complied with the, you know, the DMA obligation. And Article 5.4 is actually quite simple provision. It says, you know, you should let business users steer free of charge, you know, to their services outside the App Store. But they were, you know, believe it or not, there were discussions. So there's no discussions about economics. There were actually discussions about the language versions of the DMA, comparing the Bulgarian language version and the Spanish language version, because the free of charge was placed differently in the different versions. So I think there's 3 or 4 pages about that only in the decision, but you don't need economists for that. So that's probably a little simpler. But I think, you know, the obligation in the DMA was fairly simple. There was no market definition. There's no dominance to establish. And so we managed to get to an outcome, a non-compliance decision in 13 months. And I think that's quite remarkable. And that shows that the DMA has quite a lot of potential. There's other examples are not so great. We look at the self-preferencing investigation against Google. It's very much the continuation of the Google case in antitrust. It's very much the same issue. We are more than 2 years into the case and we still don't have a decision. Why is that? I think it's a slightly more complex process because there are more stakeholders in that one. You have Google on the one hand, you have the comparison sites on the other hand, if I'm looking at the shopping aspect, and then you have the merchant. I think the commission is struggling a little bit when you have more actors involved. And I hear Alexandre, you know, calling for more involvement of business users, and I very much agree with that. I think there should be more triangular meetings and all this, but I also have experienced in, for example, the Google shopping case, that bringing all those stakeholders together actually can slow down the process and make it very difficult to reach a solution if those stakeholders have different views. Because then the commission is like listening to something on one hand and another hand, and they need to find a compromise. And Google's been pretty good at playing those different stakeholders against each other. And then maybe one point that I think we're still not seeing the DMA delivering very well is on remedies. So we had, you know, the non-compliance decision in the App Store case. We had the one in Meta case as well. But in terms of remedies, the App Store steering case is not resolved. We're still waiting for terms from Apple that comply, despite the fact that we're almost a year after that decision. Same for the antitrust decision, by the way. I think we still don't have compliance with the steering decision on antitrust. I think on the Google case, we're experiencing very great difficulties in finding a landing zone to solve the case as well. So I think on the remedy side, there's still progress to be made. I'd like to echo very much Alexandre's point as well about the specification decision. To me, at least, this is really where the DMA is quite different from the antitrust world, right? Because the non-compliance decision under the DMA, they're not that different. I mean, you know, it's a non-compliance decision, and actually the ones we've seen, they end up with a fine and a cease and desist order. Right? It's very much like what the commission is doing in antitrust. I think that's part of the problem. The specification decision are much more of a regulatory process. The commission's going in to help or assist the gatekeepers to comply, and they specify what the gatekeepers should do. And that's much more of a regulatory mindset, I think, antitrust was, and those other decisions. And so I really hope, as Alexandre, that this tool will be used more by the commission in the future. It was very encouraging to see the commission opening those cases against Google 2 weeks ago. And one of the benefits of those proceedings is they're very quick. The commission has 3 months to issue preliminary findings and then 3 months to decide. And that's binding, unlike the 12 months soft deadline that we have for non-compliance decision. So 6 months and you have a solution. Now, whether the solution works or not, we'll see. But, you know, the Apple decisions, I think work quite well. I've been in touch with business users who start using the process. They apply to Apple for access to the specification, and it needs to be tested, but at least there's a frame that business users can use.
Great. Thanks. Felix, can we get your thoughts, especially with regard to the regulatory mindset?
Mm-hmm. Is this on? Yeah. Thank you for the invitation. Some background, I run Iconomy, a Berlin-based capacity builder, so I represent lots of the challenger tech ecosystem in Europe, so I'm heavily biased towards access seekers. We were carved out of the Internet Economy Foundation, which was founded in 2015 already by some leading founders and funders of the German tech ecosystem, because for the first time they realized what we do here, it has a highly political dimension. We need support. There was one big player in Germany that has some 60 million email users. And when Google started forcing users to make a Gmail account to sign into Android, they saw numbers drop. We had alternative search engines starting to compete with Google. And then, the second you installed them on your Android phone, you got like 16 scare screens every day saying that might really sort of undermine your privacy, that might cause more data use on your plan. So stuff like this. So a lot of people mobilized in the tech ecosystem in 2014, 15, and really engaged heavily, I think even for the first time in Brussels, in the law creation legislative process of the DMA, which is also why I believe that the DMA covers pretty much every practice and pretty much every dimension of gatekeeper misbehavior that the tech ecosystem is confronted with. So it is a very well drafted and very well adopted law. When we start looking into the enforcement, lots has been said already, but I think for a couple of points that maybe haven't been said yet. So for the first time, the DMA enforcement team is actually a joint venture by DG Connect and DG Comp. So you see a pool of staffers from the European Commission that have spent the past years on tech regulation and sort of the digital side of things, and then the antitrust folks. So there's a crazy amount of knowledge in this team. The European Commission leadership has resisted the political pressure from the US pretty impressively so far, at least when it comes to rhetorics. We were all surprised a year ago when the inauguration ceremony in the United States took place, and we saw the entire big tech line up behind Trump, and we thought, okay, what is this going to do with the DMA? And then we had a sober awakening. One thing that I want to lean in more specifically is what I said before, that I think the DMA, the biggest potential here is that it is a competition platform regulation tool that is opening up enforcement to smaller companies. Like for us, antitrust enforcement, antitrust cases were reserved for the big guys, right? You had to be a big publisher or Spotify to bankroll 15 million into hiring economists, law firms, surviving these cases. The Google shopping case showed everybody very impressively how many companies actually went bankrupt during this case. So that they're not even around anymore to file damages now. And so the DMA has really mobilized lots and lots and lots of startups, early stage startup, mid-cap players, but also big players from across the entire European Union and also other countries to really go to Brussels and engage heavily with the European Commission DMA enforcement team with insights and with lots of technical expertise and what this remedy that Google proposed here or that Meta proposed there, how would that actually work or not work, and what would that mean for access really. That also had an implication that all these players that depend on these platforms had to go to Brussels and sit in one room. I don't know how many of you are aware how this sort of procedural DMA workshops take place, but the European Commission basically invites you to sit in a room like this. Then they put Google, Apple, Meta next to them, and they get 20 minutes to basically read out malicious compliance proposals. And then the European Commission says, we're not here to comment, we're neutral, we're just providing a platform. And then it's up to us techies and us, the challenger ecosystem, to completely expose ourselves and to really just haul out the BS that we're seeing there. And then the European Commission is sitting there nodding, taking notes, but it's always shoulder to shoulder to big tech, in fact. And then we've seen a lot of brave companies that have invested, that hired people, that mobilize together in sometimes even associations, coalitions, so that they don't have to expose themselves too much as a travel tech company or an e-commerce company, but they were able to put together joint proposals and joint feedback. But now, especially with the Google 6.5 non-compliance around self-preferencing and search, we're 2 years in. A lot of these companies have invested in this process, exposed themselves entirely to Google that they fundamentally depend on, and they're not seeing any action. So right now, what we're seeing, and I'm seeing a lot, is the tech ecosystem slowly being lost for this regulatory dialogue in Brussels, and them kind of writing off this as a very dangerous experiment. There is still hope, but it's fading a little bit to an extent that's very careful. That a National Antitrust Authority president last week told me compliance by gatekeepers seems to be going rather well, right? Because we're not getting that many complaints anymore. So this is, just me trying to give a reality check from sort of the fronts of sort of the European challenger ecosystem.
Great. So let's just stay on this topic for a few minutes more. And let me ask each of the panelists to say something about how the agencies have navigated the politics versus expertise dynamic that they're facing as regulators. And give them, this is next to a law school, I guess it's the law school, give them a grade for overall performance. And at Georgetown, we don't give grades worse than C. So that should be reassuring. So give them an A or a B or a C on their current performance, just to sort of benchmark where do we go from here. So let's go in a reverse order from what we did last time. So Felix, you're up again.
So I'll have to give two grades. I'll give one to the staff level at the European Commission. They get an A. We have never seen people in the European Commission be so dedicated to meetings, to industry input, to basically you have an insight, you run an experiment, you send it over, you basically get a call with them next week. They take notes, they send you minutes. You have the feeling, wow, they're listening, something is going forward. And you also see the team really on all levels really understand it. I think that was a big surprise for lots of people in the tech industry going to Brussels, realizing there's people who understand tech on the other side of the table. That was pretty great. When we see, we touched upon it, the European Commission is a sole enforcer of the DMA. There was lots of chat a year or two ago, how much collaboration there would be with national antitrust authorities and case sharing, and every national authority has their strong suit and we will pull them in. I don't see that happen at all. I see the German antitrust authority, the French say, go speak to the Commission. We have nothing to do with the DMA. We're still very afraid to step on their toes. And I give a sadly worse grade to the political leadership at the European Commission, not because they're not invested enough, but the de facto reality being that the European Commission is in charge of trade. And Ursula von der Leyen, as the German president at the helm of the European Commission, in a country where 3.5 million jobs depend on the automotive industry, 5% of our GDP indirectly is associated with the automotive industry. 30% of the car sales go to the US. 15%, 25% tariffs to that is a major threat to what the new chancellor in Germany has promised in terms of reversing the industrial decline that we're currently faced with. So you have these people from member states calling the European Commission, and you have do we protect our little cute startups that are trying to scale, or do we protect our millions of jobs in the industry right now? And we see European Commission not having figured that out on a strategic level yet.
So if we're going to be grading politicians and not law students, I'm going to revise my grading scale so we can now use the D and the F. So you neglected to give a grade for the second, Felix. So let me just press you on that. So we got A for the staff.
Ribera gets a good one. The others,
not so much.
All
right, fair enough. It's going to take the Fifth Amendment, which is allowed. Jeremy.
So I'm just going to give one grade, and I will be so I'll use the first grading system. I won't distinguish with the politicians. I think I'll give a B, especially for the if some officials are listening, because I want them the chance to improve. And on the other hand, I want to let them know that if we're grading them again next year, it could also go down if they're laxing a bit too much. I think I totally agree with what you said on their engagement. And having done 20 years of antitrust in Brussels, I could compare the two systems, and the DMA was very much from day one an open door for business users. And as I said, I was one of them. I think as early as September, we had a meeting with the Commission, and we could already engage. And every time we wanted, we had somebody on the phone, or we could come down to a meeting in Brussels. I think that openness was really good, and it really reflects this idea of we open to involving stakeholders. But I still think that there's, they're willing to listen, but in terms of the working methods, I think we can do better. And again, that's the point about engagement, especially on the remedies. I think, again, the cease and desist method we had in antitrust doesn't work, because for big tech, essentially, they get the fine and then they don't seize, right? It's just like the fine is the cost of doing business. Right? It's going to get a fine, going to continue for as long as I'm not forced to do something else, which can come in the form of a forced remedy, which is prescribed by decision, ideally with interim measures. Otherwise, I think they will not move. So there's got to be a greater focus from the troops on designing remedies. And I think that's where this community has a role to play, to help the officials, which may not have the great imagination that you guys have in the academy, in order to come up with remedies. And I really think there should be more engagement, also from the academy with the Commission to help. And of course, the business, right? Because the business often has to have the key as to what they'd like to get from the gatekeepers. And in terms of concrete working methods, in another conference we organized a few months ago, my plea was, you need to get the business users and the gatekeepers in the room, not just for one workshop where essentially people are throwing rotten tomatoes at each other for a day. You need to do that for a whole week, if not 3 weeks, right? There'll be 3 days where, they'll throw the tomatoes and then they'll run out of tomatoes, and maybe it'll take bananas and then they'll run out of it. And then finally, when everybody will be exhausted to be in the room, they'll start talking and they'll start to, try to reach more of a compromise.
Actually called the Brussels method.
Well, yeah, exactly. That's like a council meeting, between the politicians. Now, maybe it's idealistic to think that maybe the gatekeepers, will just resist more and more. But I think what I've certainly noticed is the lack of, in-depth engagement on remedies between the business user community and the gatekeepers. It happens, with mediation of the Commission in the middle at best. So the gatekeeper sends a compliance proposal to the Commission, and then the Commission asks a few business users, what do you think? And the information goes like this. I don't think that works. And the fact that we still don't have remedies on the App Store issue shows it. The fact that we still far from remedy on the Google self-referencing issue shows it. So back to the grade, I think there's room for improvement, so that's a B, but I think there's also room to go down if we're in the same position next year with no efficient remedy, then that's mean the DMA is not working.
Great. Alex?
Look, that's a good question, David, but I think grades are related to incentive at the end of the day, for student, like for every human. And so I think what is very interesting, beside the grade, and I agree with the two previous speakers, clearly I would grade better the staff than the political level, but not necessarily because one is better than the other, but because the incentives are not aligned at the political level for the reason Felix mentioned. So I would say two things, if we want to have better grade, you have to have better incentive, and to have better incentive for the staff, I think you need to have clearer KPI, what do we want to achieve with the DMA? Because that's, to me, one of the big problems we have now is that it's not always clear, what are the KPI of success? Of course, it's contestability, fairness, and innovation, but concretely, what does it mean? And so I do think that we need to have a much, and here academia can help a lot, to develop the series, and I know some are, like Fiona and others are working on this, but to develop a series of indicators of success, and then the staff could be evaluated on this. If you manage this, you have an A. If you don't manage this, you have a B, and so on. That's for the staff. For the political level, I think Felix put it very well. I mean, you cannot be at the same time the regulator and the government of Europe. You know, and it's a bit ironical that in Europe, some are criticizing Trump for firing people at the FTC and maybe wanting to fire Jerome Powell and so on. But in fact, we have at the European level a form of unitary government because, you know, the Commission is the government and the regulator. So I think, you know, on the medium to long term, that cannot stay. We need to outsource that to an independent European authority. And what I am happy is that this idea now is taking more and more ground at the political level. So I think we will get there in some years. So, you know, if you align better the incentive, I guess the grade will be even better.
So Felix wants another whack at the problem.
I just wanted to react to what Alex said. So incentives for the political level are hard to quantify, and I think they're pretty existent. You know, you want to protect your own industry, your tech industry, from predatory practices. You want to empower your staff to take decisions and to then also file these decisions that they've drafted and have laying around for a couple of months. And you know, what political leadership also comes down to sometimes, you know, putting oxygen in a room that needs oxygen. So when, you know, Google 6.5 compliance on self-preferencing, you know, self-preferencing says you can't treat a gatekeeper service more favorably than third parties. And there is a preliminary findings decision already out there. And Google starts rolling out AI overviews 2 days after these preliminary findings were put out. They haven't done that in France. Why? Because there's political leadership in France saying, if you do that in France, we will come after you. So it didn't need a decision in France. It didn't need a proceeding in France to stop Google from these things. And I think we shouldn't underestimate the heavy importance of political leadership to empower the staff, to empower the people that are doing enforcement, to also come up with bold decisions and back them up in public, and also, you know, turn the wind a little bit towards what to expect. I mean, even gatekeepers, we had a compliance deadline on March 7th, 2024, not a start of a regulatory dialogue deadline. But all the gatekeepers treated this as we didn't see a single mock-up, we didn't see a single change, we didn't see a single test in Google. They didn't even comply with the Google shopping decision from 2018 and it's 2024 now. And there is, in my opinion, space and a necessity for political leadership to also play a role in this and not just toss this responsibility to the staff, in my opinion.
So all three panelists have talked both about the past, but lessons for the future and how we could do better. But what I haven't heard anybody say anything about so far is concerns about regulatory overload, the demand for simplification, compliance costs with multiple, you know, you've added a new regulator who's actually regulating. So how about that? Is there a pathway for making the companies your friends rather than your potential enemies?
I think we still have an issue about, you know, getting fairness and contestability and functioning market in Europe. So I don't think it's the time to deregulate or you know, limit enforcement. But of course, I'm speaking from the perspective of the ones who are beneficiaries from all this framework. I'm sure the gatekeepers have a different view about the heavy cost of regulation. I think it's a slightly tangential topic, but you know, from the perspective of people who wants to fight some of those market practices, the current times are quite interesting, especially when you compare to 10 years ago when we didn't have or 5 years ago when we didn't have the DMA. The level of optionality that we have as lawyer to build a legal strategy is very high at the moment in Europe. And you're confronted with a problem by a business user, and you know, you can look on your left and, you know, here's the DMA, do I fall into that? And, you know, you can look on your right. If you don't fall squarely in the DMA, well, maybe actually there's a Section 19 case in Germany, and today they opened a case against Amazon, which I guess could have been perhaps a DMA case. And if that doesn't quite fit, you know, you can You can also think, oh, should I go to Brussels for this one? But no, the commission's too busy or it's too much politics. And so, well, I'm going to go to court. And I think I expect in the next year, private enforcement of the DMA to expand quite significantly because we'll see the commission too busy with some of the cases or too paralyzed by the US tension. We haven't seen that yet, but I think it's going to drift in that direction potentially, or at least as a correcting mechanism, which I think the drafters of the DMA were really inspired when they actually allowed for private enforcement of the DMA, because that's a really good correction mechanism. And then you have antitrust, of course, still there, and you can go to the commission, you can go to the national regulators, you can go to private court as well. So there is a fantastic optionality at the moment. I don't think we should have less options, less regulators, at least from the perspective of a lawyer representing business users in those fights. I think the level of regulation and the design at the moment is there. And just to give one short example, I'm working on a case that some of you may have heard about, which is the Meta WhatsApp AI case, which was opened by the commission in December. It's a case that's running also in Italy and in Brazil. This was a case where we got it, we did very much that, thinking is that the DMA case because it has component of self-preferencing that are pretty obvious. And for those who don't know, it's a case where Meta is reserving WhatsApp for Meta AI only and has decided to kick out all AI assistant out of WhatsApp. And so it's pretty clear self-preferencing, but the DMA is crafted so that it doesn't apply, the self-preferencing provision doesn't apply to WhatsApp, which has been designated as a NICS, which is number independent interpersonal communication service. Anyway. And so then, but no DMA, but then we have the option of going right to the antitrust rules. And in this case in particular, we have both a national competition authority, the Italians, who jumped on it and issued interim measures in less than a month. And the commission are working on it at fast pace, they say, and we're looking at interim measures as well, hopefully in the next few months. So again, the level of optionality is very interesting at the moment and to solve those issues.
Felix, you want to say anything about that issue?
I would let Alex go first.
Alex?
Yeah, I think it's an important issue, especially because you have to realize that next to the DMA, and that is in the Draghi report, you have 100 other laws regarding digital and 270 regulators at the European level or at the national level. So clearly, optionality is good, understand that. But at some point, you have to streamline at least the institutional part, because otherwise, you risk of having decisions which are contradictory and forum shopping. So, understand that optionality can be good, but it can also be bad if it leads to, forum shopping and inconsistent decision. So I do think that, and again, I am happy to see that this debate now is really taken up in Brussels by the European institution. We need to do two things. So first, to identify what are the point of overlap, to be sure that we maximize the synergies and we minimize the tension. Okay, so that's the first thing, more at the substantive level. And then at the institutional level is to be sure that those authorities are talking to each other. And that requires, again, a question of to have sufficient legal ability and legal incentive to cooperate. And how you have those legal ability and legal incentive to do it, either because you have an obligation, and it's interesting that in the Meta case in Germany, the Court of Justice says, impose in a way, to the different regulator in the Meta case, the Bundeskartellamt, the German Antitrust Authority, and the Irish Privacy Authority, to talk to each other. And this is something you see. But that requires also that they have the possibility to exchange confidential information among themselves. And that is not yet the case, There is not, to me, sufficient legal basis for the authority to exchange more information. But so basically, we need to simplify, or at least to deal with those overlap at the substantive level and also at the institutional level by having those possibilities, those legal possibilities to cooperate more. Those cooperation take place. Let me be clear. They are taking place, but I think we don't have sufficient legal infrastructure for this cooperation to be optimal.
So one thing that's very interesting in Europe at the moment is that in Europe there is a sentiment and a realization that Brussels might have overdone it with tech regulation over the past 10 years. The GDPR is constantly being discussed as something that is really just hindering innovation. The AI Act was a big conversation because we essentially had a legitimate interest in regulating AI because there's some serious threats there. But then there were a lot of specifics, who falls under it, risk allocation, where the entire tech ecosystem looked at Brussels and thought, we thought we should play catch up here. We thought we should build. Instead, we're hiring lawyers. So this is something that exists.
Not that there's anything wrong with that.
Hiring lawyers, yeah.
Hiring lawyers.
But
yes.
you should, if you're a tech company and you have more lawyers on board than coders, then something is going in the wrong
Not
direction.
necessarily.
Unless your lawyers code. No, but this is out there, and what big tech and their proxies are doing very successfully at the moment is to lump the DMA together with this over-regulation from Brussels. So you end up seeing a German economics minister who, sorry to say, but doesn't get tech at all, go to Brussels, meet Lutnick, and then go, we need to deregulate, we need to simplify, we need to soften the GDPR, the AI Act, the DMA, because our SMEs really suffer from the compliance burden there. So the big tech is at the moment deploying a very successful job across SME ecosystems and sometimes even bigger corporates, and to say DMA is just one of these things that you have to spend compliance efforts on. That the opposite is true. If you are not one of the designated gatekeepers, you have not a minute to waste on this. This is the DMA for you is only an ability to gain market share, to get fairer access, to get fairer terms of access. And this is something that we work a lot on to push back. And even Draghi in his report made very clear, you can do whatever you like in terms of simplification, in terms of investing in your tech infrastructure. If you don't open up these platforms, you'll always bump against the glass ceiling. So yes, there is legitimate interest in simplifying digital regulation, platform regulation, but then also opening platforms and enforcing the DMA are two parts of the same coin when it comes to adding points to our GDP, and not just in Europe, also in the US and elsewhere.
So we've got about 5 minutes left for the presentation. Is there a Q&A after, or is it 5 minutes total? So let's do Q&A, and then we'll give each member of the panel an opportunity to say 1 minute what they want people to take away from this panel, other than a positive feeling about the panel. So questions for specific panelists?
There's a lot of talk and I guess a growing momentum around the Eurostack notion, or this kind of like gunboat diplomacy triggering the notion that you have to build. How do you see this interacting with this conversation in any way? And would this be a bigger solution than the DMA could ever be into potentially actually growing the startup ecosystem there?
Anybody?
I think that's a good question. I see this as complementary, actually. I mean, it all turns around partly at least the question of digital sovereignty, right? And that includes, the ability to protect our consumers and our industry in Europe, and I think that's the role of the DMA here, at least. And then the Eurostack initiative is, a bit more about building our capabilities and independence from technology outside Europe. I mean, I think for some of those critical technologies, we need not to be dependent on foreign actors, especially as the tension rises between different blocs. And the DMA is also another way to protect our internal market from the pressure from those actors. So I think this is rather complementary. On the touching on the Eurostack initiative, it talks a lot about cloud. I think what's interesting to see is the DMA reacting to that partly. So we're now having proceedings that are ongoing around cloud with the potential designation of a couple of gatekeepers in this area. But even more interesting, I think, is the Article 19 proceedings that was opened by the Commission, which is to extend some of the obligations or to adapt the DMA to the problems in the cloud sector. And I think that's I think in terms of institutional design, that's actually an interesting phenomenon happening now, which we see there was some insufficiencies in the DMA dealing with cloud problem, and the Commission is doing a market investigation to try to address that.
Any other questions?
Yeah, thank you very much. I would like to ask about the role of private enforcement, because like we had in Germany in the last year 2 private enforcement cases, and I think they were quite successful because the courts issued their decision in at least 4 or 5 months. So it was a really concise judgment, just a few paragraphs on the DMA. So it is possible to interpret the DMA without any interpretation help from the Commission, and it was very, very fast. So is this an option to do that on a larger scale, or what are the obstacles to really rely on private enforcement? Because the 2 cases were like brought by a consumer protection organization and by a very large competitor. So it's not quite that SMEs are really engaging in private enforcement, but what do you think about that? And if you say it's an option, do you see a risk of skewed interpretation of the DMA?
That's for you.
Yeah, quick one. Short answer is yes. I think there's a real future for private enforcement of the DMA. There's a cost issue, of course, for the smaller business users, and the advantage of the Commission's proceedings is the Commission's doing all the heavy lifting against the gatekeepers, and we know from my experience litigating against the gatekeepers that they will resist. It was all possible avenues, procedural and so on. So you need deep pocket to litigate against them. But on the other hand, some of the court proceedings can be extremely quick, much quicker than the Brussels proceedings at the moment. There's no political interference, so that's also really an important factor these days. And some of the obligations in the DMA they're pretty straightforward. I think if you put this in front of a non-specialized judge that's just going to exercise common sense, is going to say, well, yeah, it's obviously self-preferencing, just get rid of that. Right? And so I think it's definitely an avenue that we see people thinking more about. Certainly we as lawyers, we integrate that in our offering when people come to us and say, we have problems with the gatekeepers. And interestingly, this is no competition related, but we see the same in the DSA. The DSA private enforcement is starting to pick up, and there's some obligations in the DSA which are incredibly straightforward. There were a case in Netherlands recently. Meta was lost against one consumer association, and Meta was protesting that this is not supposed to happen at national level and this is supposed to happen at the Commission level. But in the end, the judge was put in front of a very simple question. He says, yeah, you're not respecting the DSA. Let's move on. And this is what I call sometimes, death by 1,000 cuts, right? It will be small cuts every time, but if you have many of those proceedings in parallel on similar issues, you may achieve actually your higher level of compliance than a case at the European Commission level. There's a risk, of course, of divergence. That happens. I think Alexandre has mentioned that as well. But for some of the straightforward obligations, I think that risk is clearly overplayed, and I think it's not that high. So. And if there's divergence for a while, well, so be it. And then it will go up to Luxembourg. There'll be a ruling by the Court of Justice and it will be solved. And then there will be no divergence anymore. I don't think that's a problem.
I'm obviously always happy to hear somebody so optimistic about different enforcement routes. Still, there's also other cases out there. There was a German case by a online weather company going the private enforcement route. They went to the European Commission, I think in 2019, saying Google self-preferentially treats sort of its weather box at the top of the SERP. You type in weather DC, you see the Google weather panel, right? So they went to the European Commission in 2019. The European Commission said, well, that's not big enough for us. Go speak to the German cartel office. Cartel office sent them back to the European Commission 2 years later, chewing about it. Then they went to court, went through all the stages there. The court case was very advanced. And then the court said, wait a minute, there is a self-preferencing investigation on the European level, called upon the European Commission, who essentially said, let us do this. This is part of the non-compliance investigation we're doing here. So these people look at us and go, we tried everything for 7 years, and now this self-preferencing case is delayed for over a year. When are we getting something there? So we need to make sure that you guys on the legal side, you also, do these private enforcement things publicly, so it motivates others and sets good precedents for other judges also, because I think a few judges are also very scared to do something that undermines the harmonized sort of rollout of DMA remedies across the European Union, because also big tech is very effective in threatening the Flickenteppich, the patchwork across Europe, having to comply with different remedies in different constituencies and stuff like that.
Alex, do you want to say anything?
No, not on that question, but on the previous one, in the question of strategic autonomy. And I think really the debate in Europe has completely shifted to that now, to reducing digital dependency, much more than to ensure more contestability in digital. But I think, that debate, which in a way aims to push European innovation in digital, will help the DMA will help the debate on the DMA, because in a way the DMA, and if you want to characterize, and I agree very much with what Felix was saying, I mean, it's an enabler for innovation. It's not at all like the GDPR or the AI Act, which can indeed sometimes reduce innovation. So it's an enabler for innovation. So if we push in Europe more innovation because of this debate on dependency, I guess that it will also push the importance of the DMA as an enabler for it. But I think now that's how I see the debate today. And as it has been said, it's very clear on cloud, but it may become clearer also on AI. So an enabler for European innovation, basically.
I wholeheartedly agree with what Alex has said. I'm also very involved in the Eurostack movement. I'm one of the co-founders of the Eurostack Foundation in Berlin. And I also have to say, the business community was thinking for too long that the DMA would regulate ourselves into having an industry. I think, like, enforce the DMA and, we will all thrive, but not enough resources were allocated in building. But then the topic there is also, whenever you build something, whenever you build an alternative cloud provider, 90% of the public procurement taxpayer money is spent on hyperscalers. I mean, there's 250 billion euros going across the Atlantic every year in hyperscaler services only for the public sector. So the Eurostack movement is very much centered around also, it's not enough to build, but we also have to buy European, not entirely, but with a part of it, because if we end up, the state doesn't just have a role as enforcer, it also has a role as a demand and a rule setter with that power in public procurement that there is. So the procurement directive is underway on the European level right now, and these things I think are very much intertwined, and I think that is a big favor that the Trump administration gave us. Is sort of everybody in Europe is wide awake right now in terms of our status as a digital colony, as a military full dependency, and that's also, I mean, the hard political truth under the dragging DMA enforcement. Europe has problems to even accept the smallest threat and smallest chance of Trump pulling out of NATO. Europe right now is not able to defend an inch of the front lines in Ukraine right now. So that's why the Eurostack sort of build our own capacity goes way beyond digital. It goes all across defense, infrastructure, chips, the entire stack from the bottom to the very top. And while the DMA touches more on the application layer at the moment, I would say.
So I think that's going to have to be the last word. So please join me in thanking our panel.